Welcome to LexTalks Legal Topics Simplified. Where we try to break down complex legal stuff, especially for Indian law students like you guys. And today we're going deep, deep, deep into something super important in the world of banking and finance. Uh, we're calling it suspension of business and winding up of banking companies.
Yeah, it's a really fascinating area of law, actually. I mean, you can learn a lot about how India, tries to keep its financial system like safe and sound.
For sure, for sure. It's like you're getting a sneak peek behind the scenes of how banks work, especially when, you know, things go south.
Right, right.
But before we even get to all that, we got to start with the basics. What exactly is a banking company according to, the law?
That's where things get interesting because, the legal definition is way broader than just those big banks everyone knows. You know what I mean?
Oh, okay. So, what else is included?
Well, I mean, obviously you have individuals, right?
Yeah.
But also like families, firms, associations, even if they're not like officially registered as companies, and it goes even further than that.
Oh, so it's not just who they are, but what they do.
Exactly. It takes into account the scope of their activities too. For instance, you could have a bunch of people who are like lending and borrowing money among themselves, and the law might consider them a banking company, even though they don't have, a fancy name or anything.
Hmm, that makes sense. So it's about making sure that whoever is acting like a bank is following the same rules and regulations, right?
Exactly. It's about, keeping the entire financial system stable and protecting the interests of, well, everyone involved, especially those who deposit their money, right?
Absolutely, absolutely. Speaking of regulations, I was looking through some of the laws, and wow, there are a lot of rules that banking companies have to follow.
Oh, yeah, definitely. Banking is a heavily regulated industry, and for good reason. All those regulations are there to ensure stability, prevent risky behavior, and ultimately to protect the public's trust in the whole financial system.
Right, right. So what kind of restrictions are we talking about? Give me some examples.
Okay, well, there are rules about like the minimum amount of capital a banking company needs to have. Then there are restrictions on the types of business they can get involved in, and even guidelines on how they can sell off their assets.
It's like a giant rule book on how to run a bank responsibly.
Yeah, pretty much.
But why are all these restrictions necessary? What's the thinking behind them?
Well, imagine if a bank was operating with very little capital. It would be super vulnerable, if the economy took a downturn and the depositors' money would be at risk. So that's why there are capital adequacy requirements. They act as a buffer to make sure that banks have enough reserves, just in case they need to absorb losses.
I see. So it's like a safety net for the whole banking system. What about the restrictions on what kind of business they can do?
Well, those are there to prevent banks from, straying too far from their core banking activities. Like, imagine a bank decides to get into real estate speculation in a big way. That could really jeopardize its financial health and, by extension, the money that people have entrusted to them.
Makes sense. So it's about keeping banks focused on their primary role as financial intermediaries, right?
Exactly. All these regulations are about managing risk and making sure banks operate prudently. It's all part of, preventing those too big to fail situations that can destabilize the whole economy.
Right, right. You mentioned guidelines on how banks can sell their assets. Why is that important?
Well, think about it. If a bank suddenly needs to raise a lot of cash, it might be tempted to sell its assets really quickly, maybe even below market value. And that could hurt its financial standing, and disadvantage its creditors and depositors. So these guidelines are there to make sure the process of selling assets is fair and transparent and that it protects the interests of everyone involved.
Gotcha. It's all about creating a system of checks and balances, right?
Yeah, exactly. It's about finding a balance between allowing banks to operate efficiently and at the same time making sure they protect depositors and maintain the stability of the whole financial system.
It's really interesting to see how all these regulations are interconnected, like a web of protection around the banking sector.
And we've only just scratched the surface. I mean, there are tons of rules about shareholder influence, corporate governance, and, the role of those big regulatory bodies like the Reserve Bank of India. It's a lot.
Well, speaking of shareholder influence, I came across some intriguing rules that seem to limit how much control any one shareholder can have over a banking company. Why is that?
Well, think about it. If one person or even a small group has too much power within a bank, It can like create opportunities for things to go wrong, mismanagement or even like abuse of power.
Yeah, yeah. It's like that old saying, absolute power corrupts absolutely.
Exactly. So these regulations try to spread the power around a bit more, making sure that no one person or entity has too much influence over a bank's operations.
Hmm.
So, you'll often see things like limits on the percentage of shares that anyone can hold and restrictions on transferring those shares.
Makes sense. It's about creating a more level playing field and ensuring that decisions are being made for the benefit of the entire company, not just a select few.
Exactly. And don't forget, the main goal here is always to protect depositors and maintain the stability of the financial system. That's why all these checks and balances on shareholder influence are super important.
It's amazing how much thought has gone into crafting these legal frameworks. It's like a carefully constructed puzzle where every piece plays a vital role in keeping the banking sector running smoothly.
And it goes beyond that, too. I mean, regulators like the Reserve Bank of India are constantly overseeing what banking companies are doing. They conduct inspections, issue directives, and even step in sometimes when they need to protect depositors.
So they're like the referees, making sure everyone is playing by the rules.
Exactly. They have a whole arsenal of powers, like they can examine a bank's records, interview employees, even require the bank's directors to testify under oath, if they need to.
Wow, that sounds pretty intense, but I guess it's necessary to make sure banks are operating transparently and responsibly, right?
Absolutely. These powers allow regulators to spot problems early on and take action to prevent those big catastrophic failures that can have ripple effects across the entire economy.
Okay, so we've covered the definitions, the restrictions, capital requirements, shareholder influence, and the role of regulators. It seems like there's a pretty elaborate safety net built around the banking system. But what happens when, like, despite all these precautions, things still go wrong?
Well, that's when things get really interesting. When a banking company starts to face serious problems, it can actually lead to their business being suspended or even like the whole company being shut down, winding up.
Okay, now we're getting to the heart of the matter.
So yeah, when a banking company hits a rough patch, it can lead to some pretty serious consequences like suspension of business or even winding up.
Right, like shutting the whole thing down.
Exactly. But before we jump into what those actually mean, it's important to understand like what can trigger these actions. What puts a banking company in that kind of hot water?
Yeah, let's break it down. What are the things that can get a banking company in trouble?
Well, one of the most common reasons is that they fail to meet those minimum capital requirements we talked about earlier. If a bank dips below that critical level, it's a big red flag about their financial stability.
It's like if you're building a house and the foundation starts cracking, you can't just ignore it, right?
Exactly. It means the bank might not have enough of a cushion to absorb any potential losses, which puts depositors' money at risk. And protecting those depositors, that's like the number one priority in this whole system.
Yeah, for sure. So a lack of capital can lead to some serious problems.
Right.
What else can trigger these actions?
Another big no-no is engaging in prohibited activities. Banking companies can't just go around doing whatever business they feel like. They have to operate within a very specific set of rules.
It's like they have a license to operate in one lane, and if they swerve out of it, they're going to get pulled over.
That's a great analogy. Like a banking company can't suddenly decide to become a real estate developer or start trading stocks like crazy. Those activities are outside their permitted scope and raise a lot of red flags for the regulators.
It's about managing risk and making sure banks stick to what they're supposed to do right.
Absolutely. And then there's the most obvious one, failing to meet their financial obligations. If a bank can't pay its debts, that's a clear sign that something's seriously wrong.
Yeah, that's like basic business 101. If you can't pay your bills, you're in trouble.
Right. It usually means they have a major cash flow problem, which could put their ability to function at risk and prevent them from fulfilling their commitments to depositors and creditors.
Okay, so we've got not enough capital, doing things they're not supposed to, and not paying their bills. Is there anything else that can get a banking company in hot water?
Well, there's this catch-all category called acting in a manner detrimental to the interests of depositors. And that's pretty broad, it covers a whole range of behaviors.
Like what kind of things would fall under that?
It could be anything from engaging in fraud to making risky loans without doing their due diligence. Basically, any action that puts depositors' money at unnecessary risk or undermines public trust in the bank.
So it's like a safety valve for regulators to step in if they see a bank doing something shady, even if it hasn't technically broken any specific rules.
You got it. It's all about preventing harm before it happens, rather than just reacting after the fact.
Makes sense. Prevention is always better than cure, especially when you're talking about people's hard-earned money.
Exactly. Now, let's say it's been decided that a banking company is in serious trouble. What happens next? Well, that's where the concepts of suspension of business and winding up come in.
All right, so let's dive into those. What's the difference between the two?
Think of suspension of business like a temporary timeout. It's a drastic step, but it doesn't necessarily mean the end for the banking company.
So it's like hitting the pause button to give the bank a chance to figure things out.
Precisely. During a suspension, the bank's operations are essentially frozen. They can't do their normal business, but it also gives them some breathing room from their creditors.
So it's like a shield to protect the bank from creditors while it tries to come up with a plan to recover.
That's a good way to put it. The idea is to give the bank a chance to address its problems, restructure its operations, and hopefully get back on its feet.
So suspension is about giving the bank a fighting chance. What about winding up? That sounds a lot more final.
Yeah, winding up is the last resort. It's the legal process of actually dissolving the banking company and dividing up its assets among the creditors.
So it's like saying goodbye to the company for good.
Yeah, in a way it is. It means that the company is beyond saving, and the most responsible thing to do is to shut it down in an orderly manner.
Okay, so I understand the difference now. Suspension is like pressing pause, hoping for a comeback. Winding up means it's game over. But who makes the call on which path to take? Is it the bank itself, or do outside forces come into play?
That's where institutions like the Reserve Bank of India or the State Bank come in. They keep a close eye on how banks are doing and have the power to initiate actions like suspension or winding up.
So they're like the doctors who examine the patient and decide what the best treatment is.
Exactly. They have a lot of information about a bank's finances, whether they're following the rules and how they're being managed. Based on what they find, they can recommend actions to the authorities, which sometimes means going to the high court.
So it's not a simple decision. It involves both regulators like the RBI and the courts.
That's right. It's a system of checks and balances to ensure that such serious measures are taken only when absolutely necessary and only after careful consideration.
Okay, so let's say a bank is facing either suspension or winding up. What happens to all its assets? Who gets paid first? How does all that get sorted out?
That's where things can get pretty complex. There's a specific order for how claims are settled when a banking company is wound up. And you know the main goal throughout all of this is to protect the depositors.
So they're at the top of the list when it comes to getting their money back.
Absolutely. Depositors have a special status that they get priority over many other types of creditors, so they get paid before others.
It's like they have a VIP pass to the bank's vault.
You could say that. The law recognizes that depositors are in a vulnerable position. They trust banks with their savings, and they don't always have the same level of financial knowledge as some of the other creditors. So that's why they get priority when a bank is wound up.
Well, that's good to know. What about the other creditors, though? How did they get their money back?
Well, after the secured creditors, you know those who have specific assets pledged as collateral for their loans. Then you have unsecured creditors like suppliers or bondholders. They're next in line. And the last to get paid are the shareholders.
So it's like a waterfall of payments with depositors at the top and shareholders at the bottom.
That's a good way to picture it. And remember, this whole process is supervised by a liquidator appointed by the court. They're the ones who make sure that all the assets are distributed fairly and transparently following the rule.
Like a referee, to make sure the game is played fairly, even when the stakes are high.
Exactly. The goal is to make sure everything is done in a structured and equitable way, even when a banking company is shutting down. But sometimes, even before things get to the point of winding up, there might be other options to consider, like reconstruction or amalgamation. These are kind of like lifelines for struggling banking companies.
Okay, so let's talk about those.
Mhm.
What exactly do reconstruction and amalgamation mean?
Think of reconstruction as a major overhaul of how the bank is run and its finances.
Like taking apart a car engine, fixing what's broken, and putting it back together better than before.
Perfect analogy. Reconstruction could mean changing the management team, restructuring debts, and maybe selling off parts of the business that aren't doing well.
So it's about streamlining and getting the bank back to doing what it does best.
You got it. The aim is to make the bank financially healthy again so it can operate effectively.
And what about amalgamation? How's that different?
Amalgamation is basically merging the struggling bank with another one that's doing better. It's like joining forces to create a stronger entity.
Like two trees growing together, their roots intertwined supporting each other.
I like that. Amalgamation can be a good thing for both banks involved. The struggling bank gets absorbed into a more stable institution, and they get access to resources and expertise they might not have had before. The acquiring bank gets to expand its reach and potentially gains a whole new customer base.
But what happens to the employees of the bank that's being absorbed? Do they lose their jobs?
That's a really important point, and thankfully the laws often have protections for employees during these kinds of transitions.
So it's not just about the numbers, it's about taking care of the people too.
Absolutely. Plans for reconstruction or amalgamation often include provisions for the struggling bank's employees to keep their jobs. They might be integrated into the restructured bank or the one that's acquiring it.
That's good to hear. It shows that people's livelihoods are being considered. But what about the shareholders? Do they have a say in all of this?
They definitely do. Remember, shareholders are the owners of the banking company, so they have a big stake in what happens to it. The law usually requires that they get a chance to vote on any proposed plan for reconstruction or amalgamation.
So it's like a democratic process within the company, giving the shareholders a voice in decisions that affect their investments.
Exactly. Their approval is usually needed before any major restructuring or merger can go ahead.
Okay, but what if a shareholder doesn't agree with the plan? Let's say they think it's a bad idea for the company or for their investment. What can they do?
They have rights too. The law usually has ways for shareholders to formally disagree with a proposed plan. They can voice their objections, and in some cases, they might even have the right to have their shares bought back by the company at a more price.
So it's like a way to protect those shareholders who might be in the minority and feel like their interests aren't being considered.
Exactly. The law tries to balance the good of the whole company with the rights of individual shareholders, especially those who might not agree with the majority. But even with all these safety measures in place, there's a big question that we need to address. What happens to the depositors when a banking company is in trouble?
Yeah, that's the question that's been on my mind throughout this whole discussion. At the end of the day, it's the depositor's money that's on the line. It's like we've been on this crazy journey exploring all these banking regulations.
It can definitely feel like navigating a maze sometimes.
But one thing has been super clear throughout our deep dive. Protecting depositors is like the top priority.
Absolutely. I mean, everything from those early ordinances to the Banking Regulation Act, it's all ultimately designed to safeguard those who trust banks with their money.
Makes total sense. Depositors are the backbone of the entire system. They keep the whole thing running.
Yeah.
But how does that protection actually work? Like what happens if a banking company goes belly up and they're heading towards winding up? What happens to the depositor's money then?
Well, that's where the Banking Regulation Act of 1949 really comes into play. It lays out a specific order for how claims are settled during winding up. And guess what depositors are right at the front of the line?
So it's not like everyone just dives in and grabs whatever they can.
No, not at all. The Act takes into account that depositors are in a vulnerable position. They're not like big investors or lenders. They're everyday people and businesses who rely on banks for their daily financial needs. So the law makes sure their claims are prioritized ahead of a lot of other creditors.
That's good to hear. It's reassuring to know the system has their back. But what about situations where winding up isn't happening and the banking company is going through like reconstruction or amalgamation? Are depositors still protected during those transitions?
Absolutely. Remember those schemes we talked about that the state bank or the reserve bank can come up with during a moratorium? Well, they're not just about restructuring finances or merging banks. They also have safeguards built in to protect those depositors.
So it's like baking in depositor protection right into the recipe for recovery.
Exactly. And these safeguards can work in different ways. For example, those schemes often guarantee that depositor accounts are transferred to the new entity without any loss of funds. They might also make sure that interest keeps adding up during that transition period.
Okay, so that covers the financial side of things. But what about the practical stuff? Like, I imagine merging banks could create a lot of confusion for depositors with new procedures and account numbers and all that.
You're right, that's a valid concern, but these schemes often address those issues too. For instance, they might allow depositors to use their existing checkbooks and ATM cards for a while, even after the merger. And keeping depositors informed about any changes and answering their questions, that's crucial.
So it's all about making things as easy as possible for the most important people, the depositors.
Precisely. The goal is to minimize any disruptions, keep things running smoothly, and maintain that trust in the banking system. It's all about making sure depositors feel like their interests are being taken care of every step of the way.
Well, this all sounds pretty reassuring, but let's be realistic for a minute. Are there any situations where a depositor might actually lose money, even with all these safeguards? It's important for our listeners to get the whole picture.
You're right, transparency is key. While the legal system goes to great lengths to protect depositors, there are a few situations where losses could happen.
Okay, I'm listening.
One scenario is when a banking company goes into liquidation. That means its assets are sold off to pay its debts. And if those debts are bigger than the assets, there might not be enough to pay back all the depositors in full.
So it's like trying to split a pizza that's too small for everyone to get a full slice.
Exactly. In those cases, depositors might get a portion of their money back, but not everything. It's not ideal, but the law tries to make sure whatever funds are available are distributed fairly.
I see. Are there any other situations where depositors could lose money?
Another one, though it's not very common, is when a bank is involved in fraudulent activities. If those activities lead to big financial losses, depositors might be impacted, even with the protections in place.
So even the best legal system can't fully protect against intentional deception, huh?
That's right. The law can try to prevent and punish fraud, but it can't eliminate all risks. That's why it's so important for banks to operate with vigilance and follow sound practices.
Well, we've covered a lot of ground today. What are the key things our listeners, especially those future Indian law stars, should take away from this discussion?
I'd say the biggest takeaway is that India's legal framework for banking companies, while complex, strikes a balance between regulation, protecting depositors, and ensuring the whole financial system stays stable.
It's like a carefully choreographed dance where every move is designed to create harmony.
Exactly. For anyone interested in banking law or finance, understanding these interconnected parts is crucial. It's not just about memorizing laws, it's about grasping the principles behind them: capital adequacy, strong oversight, and making sure depositors feel secure.
Those are great words to live by in the banking world. Thanks for joining us on this fascinating deep dive into banking law. Hope you found it as insightful as we did.
My pleasure, and I encourage everyone to keep learning and exploring this important field. It's always evolving.
Thanks for listening, everyone. Don't forget to subscribe to Lex Talks for more deep dives into the world of law.